The broadcast is now starting. All attendees are in listen-only mode.
Hi, this is Jennifer Schaus, and welcome to our government contracting webinar series, summer of 2017. We are in week 3 of our webinars and still have a couple more weeks to get through, covering many topics in contracting. Today we are lucky enough to have Mary Beth Bosco from Holland & Knight with us, and she's going to talk about contract terminations. So thanks everybody who was able to join us, and thanks to Mary Beth for being with us today. Okay, bear with me as we're having some technical difficulties with the slides here. As I mentioned, this is a series. The full schedule and recordings are found on our website under the webinar section. So they are complimentary to download. For anything that's already been completed, scroll down below the schedule to find the recordings. A little bit about us. We are based in downtown Washington, D.C., providing various services for contractors, both product and service companies, domestic and foreign, anything from market analysis reports to capability statements, proposal writing, 8A certification, GSA schedules, contract admin, and so forth. We also host various events and seminars throughout the year. You can find those on our website under the events section, or an easier way would be to sign up for our newsletter, which reaches about 11,000 government contractors around the world. A little bit about me here, but more importantly, I'd rather jump into a little bit about Mary Beth, her background. She'll share some information about Holland & Knight, and then we'll dig into the presentation. So Mary Beth, thanks again for joining us today. I'm excited to hear your presentation, and I'll let you dig into the topic here.
Sure. Thanks, Jennifer. Not too much about me. I'm a government contracts attorney. I practice in Washington, D.C., and also I actually live in the Tampa, St. Pete area, so I commute back and forth. So I've got a little bit of reach in Florida as well. Next slide. Holland & Knight is a law firm of about over 1,200 attorneys. We're largely based in the United States, and we've got offices in many cities where there are mass of government contractors, not just here in DC and Northern Virginia. Next slide. And then let's go into the slide after that, the introduction. So today we're going to be talking about terminations of government contracts, a little bit about why this is becoming a more important topic, why it's a little bit different than commercial contracts, spending most of our time on terminations for convenience because you are entitled to reimbursement for your costs incurred in a contract that's either terminated in whole or in part, and so what you can include and what you can't include in those costs we'll cover, and then finally a little bit on terminations for default. So next slide. One of the things that prompted my interest in doing a termination webinar is that we are certain to see some more budget cuts, especially to civilian agencies. And the current administration is, as we've heard, talking about overhauling the government and changing certain program directions. So, for example, the air traffic control system, there's a proposal to privatize it. The VA records management system is being made compatible to that of DOD's, and they're going to use the DOD contractor. So you've got existing contracts for some of these programs already, and the question is what's going to happen to them. Most likely, the government is going to have to terminate them for convenience. Next slide. So government contracts sort of are unique in one way in that they contain terminations for convenience clauses. And these clauses came into effect after the Second World War because the government had a number of ongoing contracts for defense articles and support for the defense war effort and no longer needed those services, but it would have been unfair to just stop those contracts without fairly compensating the companies for what they had, the costs they had sunk into the programs up until the termination. The government can terminate a contract at any time for its own convenience. It really doesn't need to have a reason. In practice, its ability to terminate for convenience is limited because it cannot be undertaken in bad faith. But bad faith is extremely hard to prove. In fact, I like to say that in the history of the world, there have only been a couple of cases that have found bad faith in the government's decision to terminate a contract for convenience. So they're hard to appeal. So let's get into the logistics, what actually happens. So if the government wants to terminate a contract for convenience, it could either terminate the whole contract or it could just terminate a part of the contract. It is started by a written letter from the contracting officer, and the contractor has several things it has to do immediately once it gets one of those letters. First of all, it's got to stop work immediately on the terminated portion of the contract, and it has to tell all of its subcontractors that they're being terminated as well. The contractor, is also to advise the government, that the termination contracting officer, of any special circumstances precluding stoppage of work. For example, if you stop doing something, will it create some type of a safety hazard? Are you in a portion of a construction contract that just can't be ended without creating some kind of a problem, or something similar to that? And then basically negotiate with the TCO as to what needs to be done to address that particular issue. Next slide. So after you've stopped all work, there is a formal process within the Federal Acquisition Regulation as to how you submit a termination settlement proposal. So the FAR has already said if you're terminated for convenience, you are presumptively entitled to some type of recovery. And the FAR walks you through what is supposed to be included in that termination settlement proposal and what is to be excluded. Now, one of the interesting things, and we'll talk about this in a little more detail, is that, as I said before, you've terminated your subcontractors, but they in turn are going to have incurred costs that they want to recover. So your termination proposal is going to have, as the prime contractor, is going to have to include your subcontractors' termination costs. And you, as the prime contractor, or if you're a subcontractor, you need to know these rights, will have to negotiate with one another to come up with a settlement proposal that is really, you come up with a settlement itself and you're presenting that to the government for payment. If you have a fixed price contract, a termination for convenience effectively converts it into a cost reimbursable contract. In other words, you are entitled to recover the cost you have incurred to date in performing the fixed price contract, regardless of the fixed price. Next slide. So like I said, the FAR tells you what needs to be or what should be in your termination for convenience cost proposal, to the extent you have these categories of costs. And this slide lists them. Do you have inventory that you've purchased for the contract but you haven't had a chance to use yet? You can claim those. What about finished parts or works in progress, things that you have not completed but you've incurred cost? You can claim for those. Did you have to buy special equipment or special tooling or anything else that you would only need for purposes of performing this contract? If that's the case, then you're allowed to recover the cost of acquiring those items. You can put G&A and also profit. You're allowed to recover profit on your termination costs unless the contract is projected to be a loss contract. We've also talked about subcontract settlements. So once the prime has reached an agreement with the subcontractor, that amount is included in the prime's proposal to the government. If you've got any credits to issue, or if you've been able to say sell some of that special tooling to someone else, you would include those in the proposal as well. So that's the category of costs, and we'll go into a little bit more detail as to what that means and what costs are actually allowable. So if you have, we talked about special tooling, special equipment, but what about common items, things that you have on hand that you can use on other contracts or other work? Typically, you're not going to be able to recover for those costs unless you can show the government, hey, wait a minute, if we've got to keep and pay for these items, maybe we can use them on other contracts, but we're still going to be at a loss here. We're still not being made whole for the fact that you've terminated this contract for convenience. So some of those costs may be recoverable. What about costs that continue after termination? Things like idle facilities. What about if you've entered into some kind of a long-term lease or contract for employees, say with an employee leasing agency, and you can't get out of it? They're going to be generally allowable if you've taken all the reasonable steps you can to end that situation of idle facilities or an ongoing contract. If you can't, then you're going to be able to recover them. What about initial costs? Let's say you have some learning curve costs that you had anticipated would be recovered over the course of the contract, and now the contract's been shortened. You should be able to recover those costs, if you can show the government, what they are with some degree of certainty and precision. So record keeping is very important to termination for convenience proposal. You'll need to be able to show that anything you're claiming was used on the contract, was expected to be used, that you had the expectation that the cost would be, absorbed over the life of the contract. Next slide, please. So this talks about, in a little bit more detail, this slide, what we just talked about. Loss of useful value, rental cost under unexpired leases also are, as we said, allowable. The termination is very interesting because once you're terminated, if you've got subcontractors, you've got to start negotiating with those subcontractors, and we'll cover that in a little bit more detail. But unlike, there's a general rule in government contracts, you're not supposed to be able, as a prime, to recover profit on a subcontractor's profit. Well, in a termination situation, you can generally put indirect expenses on top of your subcontractor settlement. You're also allowed to recover settlement expenses. So if you had to hire an accountant, let's say, or an attorney, or even the cost of your in-house personnel to put together the settlement package and say to do the negotiations with your subcontractors, those expenses are recoverable and should be part of a T4C settlement proposal. Next slide. There's a little bit of a twist when you're talking about a commercial item contract, because in those cases, presumably, because you can sell the item both to the government and to commercial customers, there's a little bit more difficulty proving that something was bought solely, or the labor was solely for the government contract. So what the FAR does to remedy that is to say, if you've got a commercial item contract and it's been terminated, your recovery will equate to a percentage of the contract price that reflects the percentage of work that's performed prior to the notice of termination. So, you're not going to have to put together such an extensive termination proposal. Rather, your recovery will be based on essentially the percentage of the work that you have performed. Next slide. So now we're getting into a little bit more detail about your subcontracts. And again, if you're more of a subcontractor, this slide will sort of, by the flip side, tell you what your rights are. So the first thing for a prime is that you've got to think about, when you're forming your subcontracts, have you put a parallel provision in your subcontract that A, allows you to terminate that subcontract for convenience if you're terminated by the government, and B, tells the subcontractor what it needs to put into a termination settlement proposal, because obviously the closer that the subcontractor proposal reflects what's in the FAR, the easier it will be for the subcontractor and the prime to come to an agreement and therefore submit the package to the government and get paid quicker. Primes are allowed to settle. You don't have to get the government's approval to settle with the subcontractor to put it in your proposal. The only decision the government makes is, was it arrived at in good faith? Is it reasonable? And is it allocable to the terminated portion of the contract? So as long as you keep those three things in mind, you as a prime contractor have the authority to settle with your subs and then include that amount in your own proposal. Next slide, please. So that concludes the basic on terminations for convenience. The takeaways are, the government can terminate for convenience pretty much at any time for any reason. But the good news, if there is good news, is that you will be compensated for your costs incurred in performing the contract up until the termination date, including costs for things like special tooling or education or equipment that you could not recover for fully. The other headline is there is a sort of special relationship between subs and primes once there's a termination for convenience, and the quicker they can align and come up with an agreement to settle the subcontract claims, the sooner they can put in a claim to the federal government and get paid. So moving on from that, talking about terminations for default. So a T for D is something that is much more aligned with what you'll typically see in a commercial contract. You can be terminated by the government just like any other owner or buyer for failure to perform under the contract. The difference is that the government usually must give you an opportunity to cure the default, whether it be a failure to meet the specifications, a failure to deliver on time, or the failure to demonstrate an ability to get the contract done. In deciding whether to terminate, the government will, for default, will look at things like, can we quickly get these supplies or services from other sources, and is there an urgent need for the services. If there's an urgent need and the government's not going to be able to get the supplies or services quickly, that weighs in favor of giving the prime contractor another chance. Next slide, please. In terms of a fixed price contract, the government can actually terminate fixed price contracts without that cure period that we just talked about. If there is some other contract requirement or there's sort of a general lack of progress, the government can give the opportunity to cure. So basically, when you got a fixed price contract, if you are totally failing to deliver on time, you can get terminated without a cure period. If there's some other contract, or if the government is starting to get nervous about your ability to deliver on time, then it can give you an opportunity to cure. Interestingly, if it's a small business, and this is something to remember, the contracting agency has to tell the SBA that it's issued a cure notice. So that's something to keep in mind. Another thing is that if you're terminated for default, you may be liable to the government for liquidated damages, or what we call excess reprocurement costs. That is, if the government goes and gets the supplies or services from somebody else and there's a delta between what it paid and what your contract said, you may be responsible for the delta. Next slide. Cost reimbursement contracts, there is a 10-day notice period that's required in all, all contracts. It's similar when you terminate a cost reimbursement contract for default. The contractor will get something of a termination for convenience settlement. It's allowed to be reimbursed for all of its costs that it has incurred to date, so long as the supplies or services have been accepted. The difference is that, the main difference is that you can't get the cost of preparing the proposal, the settlement proposal, or the settlement costs. Next slide. When you think about termination for default, another always keep in mind is that it will have an impact on things like your past performance evaluation, your future responsibility determination, and that some state and local solicitations require disclosures of termination for defaults. So you should be aware that they can very often live with you long after the contract is over. Next slide. And that's it. Like I said, termination for convenience is a bad thing, but there's a little bit of a bright side because you get your cost recovered. A termination for default is always a bad thing, as you can imagine, and keep in mind that it has consequences long after the termination has happened. And that is the presentation on terminations.
Thanks, Mary Beth. Great information. Obviously, terminations are not what vendors are seeking, but it looks like they've got some rights both as a prime and a subcontractor. So thanks for sharing your insight, your expertise, and your knowledge. Mary Beth's contact information is on this slide. Tomorrow we are covering best practices for teaming agreements. Thursday, contract negotiations, and Friday we cover the FAR flow-down clauses. Again, these are all complimentary. All the webinars are recorded, and again, if you have questions about contract terminations or even cybersecurity, which Mary Beth covered, I think last week or the week before, you could contact her at marybeth.bosco@hklaw.com. Thanks, everybody, for joining us.